prosecutor sounded a little frustrated in his voice, and he said, listen, 5 different medical conditions. They just got a writ denied on Tuesday, and here we are facing a continuance. Do you think the prosecution has a leg to stand on in forcing this trial to go forward?
Obviously, they're doing their best. Basically, what they're trying to tell the judge is this is just an excuse. It's just another way to getting the trial continued. They've tried it many times, and they've even filed a writ, and their writ was recently denied a couple of days ago, and now we've got this. And his best argument, the prosecutor's best argument is, all this information was available to the defense, and the information goes back not just a few months, but years. So they waited all this time to bring this up. The timing is it just a coincidence, or you know what? They lost some of the other motions, and they lost their writ with the appellate court, and now this is their desperate attempt to get a continuance, and they're willing to use anything, including Robert Durst's health issues, to get this continuance.
And regardless of the reason for a request for a continuance this close to trial, any trial attorney who's tried a lot of cases, or even just a few cases, knows the amount of prep time that goes into preparing for any case, much less a murder trial like this with years of evidence and an old crime, and the jury started before COVID, so you've got to ask the jury some new questions and then move forward in 5 months. I mean, it's phenomenal, and I think that people don't always realize, if they're not in the legal profession, the amount of legwork it takes to go in and be prepared for a trial of this caliber. Do you feel, as a criminal defense attorney, that if this trial goes forward and is not continued, that they have been able to spend the time necessary to prepare, or have the medical conditions alleged of Robert Durst prevented them from being able to prepare in the way that they'd like to?
And that was something I was going to bring up, and even before you asked the question. Now, if your client is physically ill, sometimes it's physical, other times it could be psychological, where they can't help you. They're not competent to help you, and that's usually when there's psychiatric issues. And if they're physically ill, again, it's hard for them to focus. It's hard for them to move. Remember how they were saying he's in a bed 90% of the time? How can he help his lawyers? He needs to be able to help his lawyers defend him. And that's a substantial and an integral part of the right to a fair trial, right? His ability to help himself through communicating with his lawyers and working with them on his defense. So that's a huge argument. And then, I'm sure the judge is going to have to balance that against this idea that, the prosecution and other witnesses' right to expeditious disposition of criminal cases, which is a part of this Penal Code Section 1050, right? It's one of the considerations by the judge. Everybody, victims, witnesses, and the defendant, have the right to an expeditious disposition of trial cases, which are always prioritized versus civil cases and other cases. And the court is going to consider that as well and make that decision of, what's popping out more here? What's really at stake here? Can he give this particular defendant a fair trial?
And let me stop you
if
there.
he pushes them.
We're about to take a break, so I'm going to stop you there only because I think it is true that is he mentally competent to assist, or is he not able to because of the physical? Up next, we're going to bring you the latest updates out of Iowa. This